फुल रेडी ना तू तुला अनम्यूट करतो. Yes.
Yes, sir.
Now our meeting is live streaming on YouTube channel New Law Guruji, and almost 100 plus participants are there. I request Advocate Prafulla Lele to introduce Honorable Dr. Sanjay Jain sir.
Yes, thank you, sir. Good evening, all. It's my pleasure to introduce our beloved principal, Dr. Sanjay Jain sir, on this online platform, where we all will be privileged to hear from him. Very interesting topic about amendment and particularly focusing on First Amendment and the amending power of Constitution under Article 368.
Yes, you can
sir.
continue.
Yeah. Jain sir is presently working in ILS Law College as an associate professor, and he is additional in charge as a principal of the ILS Law College. Sir has completed his PhD in law in topic of taking women seriously, a critical inquiry into the changing parameters of judicial review and perspectives on protection and enforcement of rights of women, with special reference to Constitution of India in February 2010 from RSTM University, Nagpur. Sir has been working in educational field almost since 22 years. He is teaching at PG level he has a honorary lecturer for administrative law in PG Department of Law, RSTM University of Nagpur. Then he has also been as a contributory lecturer in Indian for the subject Indian Constitution and Human Rights in Academy of Human Rights, RSTM University, Nagpur. He has also been the contributory lecturer for jurisprudence and legal essays in Dr. B.R. Ambedkar Marathwada University. He has also a full-time lecturer in Department of Law, Savitribai Phule Pune University, Pune, from April 2005 to April 2007. And there he was teaching various subjects like labor law, IPR, international trade law, central excise, banking laws, FEMA. He is also an honorary faculty in postgraduate department of law at ILS Law College from 2010 onwards, and he is engaging lectures on assigned themes with constitutional law, jurisprudence, law and social transformation. And personally, I have witnessed several lectures at Department of Law in ILS, like on parliamentary privileges. He has also been a full-time lecturer in ILS Law College from March 2008 onwards. Before joining ILS, he has started his journey from Bharati Vidyapit's New Law College in 1997 as a full-time lecturer. Then he joined MLNG Society MP Law College, Aurangabad. And there he was since 1998 to 2005, and from 2007 to 2008 as a full-time lecturer in law. Sir is currently, as I have mentioned, Sir is currently working as associate professor in ILS Law College and additional in charge as principal of ILS Law College. There are various awards bestowed on Sir for his professional competency, and to quote some of them, I would like to say that National Award in the Employee category at the auspicious hands of Honorable then President of India, Dr. APJ Abdul Kalam, on occasion of World Disabled Day, 3rd of December 2004, instituted by Ministry of Social Justice and Empowerment, Government of India. Also, he has been conferred with the award of Professional Competence Award by Rotary Club, Simvagat Charter, Pune in November 2006. Miss Pilu Duraf Khambata Memorial Award 1999-2000 as an outstanding blind employee by NAP in India. Just to mention here, Sir, there is a 100% loss of sight with both the eyes by birth, and Sir has completed his PhD overcoming all this kind of situation. And sir is working tremendously, and we all at ILS, we all have him as a role model, how to work and how to engage in all kind of work in research activities and also in the administrative work. Sir has almost, sir is a PhD guide. He has appointed as an academic and research coordinator of ILS Law College as per the mandate of Savitribai Phule Pune University from 2017. Sir is PhD guide, recognized guide for PhD in law, Savitribai Phule Pune University from 2013, and presently research supervisor for 5 PhD candidates in law. Sir is also member of Advisory Board, Indian Law Review. He is also mentor and research policy initiative lead of Wednesday Foundation and consulting editor. And he's also consulting editor of a journal of disability studies published by TIS, that is Tata Institute of Social Sciences. If I start reading his contribution in the research field, particularly to the legal fraternity, almost it will take half and more hour. Sir has participated in more than 69 to 70 international conferences, and in those conferences, I would just like to say that in how much conferences he has presented papers and in how much conferences he has attended those conferences. So to just we can get a quick review of how much tremendous work sir has done. Sir has participated almost in 23 international level conferences, seminars or workshops, and almost in 24 papers have been presented in various international conferences. Sir has also participated in national conferences, seminars and workshops, and 60 papers have been presented at national level conferences, and 59 conferences sir have attended those national level conferences. So almost he has attended 120 conferences till date. Sir has participated in 51 local level seminars and workshops and conferences, and 39 papers have been presented. And till date, sir have delivered 92 guest lectures, and I guess that is a very big number if you consider giving guest lecture at various institutions. I always say that Jain sir is an activist, and so let us have a review of his activism. Sir is designated as a disability right consultant on the scientific committee of 3-day national consultation on rights of persons with disability scheduled for November 2019 to be organized by Indian Social Institute at New Delhi. Sir is nominated as a member on the editorial board of Legal News and Views March 2019 onward. Sir is also actively working as a member of selection committee for the interview of appointment of various legal officers in the district commissioner office since August 2018. Sir has also provided guidance to various students who desire to participate in Avishkar research competition. Am I audible? Hello.
Yes, yes.
Yeah, actually there is some range issue, so I just checked whether I'm audible or not.
You're audible. You continue.
Yes, sir. To mention several international conferences, Sir participated in ICON S 2016 conference on borders, otherness, and public law, and the theme of the conference was is Supreme Court, the guardian of Indian Constitution, reflections on constitutionalism in India, philosophical lens of Kelsen and Smith, Sir has presented the paper on this particular subject. Also, sir has participated in ICON S 2015 International Constitutional Law Society Conference, and the theme was Public Law in an Uncertain World. And sir has presented paper on implementing the obligation to provide reasonable accommodation to persons with disability, comparative analysis of position in India, UK, and USA. And also he has addressed in the same conference another paper addressing the interactions and encounters of doctrine of principles with texts and rules in the constitutional design and special focus on India. This particular conference was held in New York in USA. Sir has also attended various conferences like in Italy, Hong Kong, and various other international places. In inaugural conference on rethinking the boundaries of public law and public space, Sir has presented Disability in Constitutions, a critical analysis of exclusionary constitutionalism. And this conference was held in Italy. Apart from the conferences, Sir has authored and co-authored in various books and various chapters. He has contributed to various books as author and as co-author. Sir is also director of PhD Research Center, ILS Law College, Pune from April 2016. He is also a member of advisory committee constituted by MKCL India for the production of television serial on Constitution of India for Doordarshan in 2015-16. He is an external paper setter for LLB and LLM examination in the Symbiosis Law College and Deemed University, Pune. He is an external examiner for conducting Viva for LLM students, New Law College, Bharati Vidyapeeth. He is also coordinator of steering committee of MP Law College, Aurangabad. He has actively participated in various activities and he was a member of Criteria 3 for NAC accreditation. His chief area of interests are feminist jurisprudence and gender justice with special reference to Indian situation, comparative constitutionalism, sociological jurisprudence, disability right jurisprudence, human rights of marginalized groups, legal theory and jurisprudence, international economic law, and various other field of interest which I'm not mentioning due to paucity of time. Sir has also keen interest in light music, and sir also plays synthesizer, and he keeps watch on various activities happening around regarding the light music also. So I guess this is a brief introduction of our esteemed guest Dr. Sanjay Jain sir.
Over to you, sir.
Thank you very much, Praful. I don't think it was a brief introduction. It was a very long introduction. And I feel slightly nervous having been introduced so extensively. But I think let's leave aside the introduction and now get back to business and talk about today's topic, which is assigned to me. And that is, amending power under Indian Constitution with specific reference to the First Amendment. But before I embark upon my topic, of course, I would fail in my duty if I don't profusely thank the organizers of this NBT Law Guruji lecture series in general, and my friend Sandeep Sadbhai, Professor Sandeep Sadbhai in particular, for engaging me in this interesting topic. Right? I could also find some of the familiar people watching this lecture, hearing this lecture. Particularly, I would like to mention one of my dearest students, Sharat. I think he's listening to me from Chennai, and my another student, Maithili, she's also there, and some of my one or two of my colleagues. I think I would apologize if I don't recognize everybody, but I think there are quite a few people whom I know, and there may be others whom I don't know. So basically, those who know me will test me about whether I'm speaking relevant, and those who don't know me probably will get a chance to find out whether anything new is coming from me. So both ways, I think it's a interesting scenario. Now, having made these observations, let us go to the topic straight away and start the discussion. Now, to keep the discussion moving, what I've done is I've divided my talk into two parts. Part one is a general discussion on amending power, with specific reference to basic structure. And part 2, of course, is First Amendment. Now, many of you would be many of you must be wondering why I'm talking about First Amendment. What is so special about First Amendment? It's history now, right? But recently, a youngster whose name is Tripur Daman Singh, he has written a very intelligent, very interesting book. Sorry, the title of the book is 16 Stormy Days. It's a terrific book in which he has taken stock of the history of the enactment of First Amendment. And really, that book, I started reading and I completed it in 2 or 3 goes. Such an interesting book. All of you should read, because not only this book gives you the opportunity to engage in law and history, but also makes you aware about the agility of the public in 1950 about the Constitution, how press was reacting to the Nehruvian plan, how the intelligentsia at that time was reacting. So all those things, what was the reaction of President Rajendra Prasad, how the opposition reacted. So all those things you come to know, and I will try to engage with all this very briefly in my second part. But let's go to the first part. Yeah, and before I start, let me say very honestly that I dedicate this talk to my teacher, Dr. Deshpande, with whom I always enjoy discussing. And before delivering this lecture also, we had a huge discussion, and as usual, we agreed to disagree, right? Now, let's start the discussion. Now, the first slide, first slide which I would like to share with you is about, first few slides rather, they deal with the constitutional location of amending power, right? Where to locate the amending power exactly in the Constitution, right? Now, a typical answer would be that, okay, the location of amending power is Article 368. But if you go deep down, then, and if you probably take Professor Upendra Bakshi seriously, if you read his piece, Little Done, Vast and Done, then Bakshi very clearly says that constituent power is also shared by the other organs of the state, and particularly judiciary. Now, if you take Justice Subba Rao seriously in Golaknath's case, he thought that amending power, he was in fact searching the amending power. He was searching the location of amending power. He did not find any specific provision in which he would locate the amending power, and ultimately he had to resort to the residuary power article, Article 248. So exactly where we have to locate the amending power, that is the question. And although after Keswanand Bharti, some people may say that now court having declared 24th Amendment to be constitutionally valid, now the location of amending power is very safe in the staple of Article 368. I will demonstrate that that may not be the correct position of law, or at least it is a very suspect position of law. Now, the second important aspect regarding the amending power is its nature. What exactly do we mean by amending power? Now, if you read Article 368, the marginal note says it is a constituent power. In fact, not the marginal note, the first clause, the constituent power. Clause 1 of Article 368, Clause 1, Clause 2, if you read together, it very clearly talks about constituent power. In famous Nagraj case, Supreme Court recognized this terminology. Supreme Court said that Parliament has the constituent power. But Supreme Court also copiously quoted Sirvai to mean and probably to imply also that it is a derivative constituent power. So on one hand, court is saying that parliament has a constituent power, but by quoting H.M. Sirvai, court is also at interpretative level saying that it is a derivative constituent power. Now, if you refer some of the famous textbooks or famous treatises on the subject. So Yaniv Rozniv, Professor Yaniv Rozniv from Israel, recently has come out with a very interesting book in the Oxford Constitutional Theory series, Unconstitutional Constitutional Amendments. Now he says that there is nothing like, I mean, he does not accept this distinction between constituent power and derivative constituent power. He says that the power to amend is simply the amending power, but he says that it is a sui generis power. This power is outside a particular, this power is outside the law. This is a sui generis power. This is a special power. And then he says that this power may be divided into primary constituent power and secondary constituent power. Now he says that the primary constituent power is generally exercised to constitute an instrument like Constitution of India, for example. When you constitute an instrument like Constitution of India, when a body sits and constitutes an instrument, so it is the exercise of primary constituent power, and there is complete deference to this power. Courts will not intervene. I think only exception to the same is the South African Constitutional Court, which had raised objection to the interim constitution, saying that it is not compatible with the, it had identified some 36 features which should have been added in the constitution. So the constitution was again sent back to the assembly. But barring that example, generally there is a total deference to the exercise of primary constituent power. On the other hand, when it comes to secondary constituent power, it is exercised by a body which is a constituted body. For example, legislature, parliament. Parliament is a constituted body. This body is constituted by the constitution. So therefore, it is possible to argue that that the secondary constituent power exercised by the legislature is not amenable to deference, and it is amenable to judicial review. That is the framework provided by Yanni. There is a German scholar, Professor Kahn. He argues that in the era of globalization, can you locate the constituent power in a particular document? For example, document like Constitution of India, or document like Constitution of France or Constitution of Hong Kong, because a legal order is in conversation with so many other legal regimes, and a particular legal order has to commit itself to several other regimes. For example, by becoming the member of WTO, India has given commitment to the obligations flowing from the WTO treaty. Now, as a state party to the WTO, can you argue before WTO that, okay, I will not be able to perform my obligations arising out of the Marrakesh Treaty? Why? Because such obligations are contrary to my constitution. In other words, what has happened? Willy-nilly, by signing and ratifying and to be the part of an international organization, you have expanded your horizon. And once having given the commitment to the international legal regime like WTO, you cannot go back. You cannot resile from your obligations. And therefore, Professor Kahn argue that constituent power now is no longer, it is the no longer it can be housed only in a particular document like a constitution. In fact, it is a very dynamic power, and it keeps on moving. It keeps on traveling with the progress of the country. So he's saying that there is nothing like constituent power being confined in a particular document. Now there is another school of thought. Now that school of thought says that it challenges the distinction between constituent power and constituted power on the ground that on the ground that there is nothing like accomplishment of a constitution. So the premise of this school of thought is there is nothing like complete accomplishment of constitution. So for example, to cut short or to make the matter simpler, in 1950 when we inaugurated the Constitution of India, whether we accomplished the constitution, this school of thought, according to this school of thought, we only made the beginning of the constitution. And if you follow Professor Bakshi, who very eminently looks at the Indian constitution in terms of various C's, and I think according to him, first amendment was the first C, then Golaknath was the second C, then Keshwanand was the third C, second C, first C means first constitution, second constitution, third constitution. That means with each of these events, we were having a new founding. In other words, this school of thought says that because constitution is always a work in progress, constitution is never going to be completed because it is a dynamic document and you have to keep it in pace with time. Therefore, to say that once the constitution comes into existence, constituent power vanishes, the typical Carl Schmittian view, that view is challenged by this school of thought, because this school of thought says that constituent power continues because constitution also continues, right? So that is these are some of the very fascinating theoretical issues. Then another interesting aspect linked with constituent power is now it is said that can you use constituent power to destroy the very basis by which it is created? So, for example, Constitution of India has conferred the amending power on the Parliament. So, can Parliament use this power, use its amending power to destroy the Constitution, to completely deny the Constitution its original identity? Now, one school of thought is that if power is not to be exercised for suicidal mission, then it has to be assumed that no public power comes without limitation. Every public power has a set of limitations. Therefore, according to this school of thought, even if explicitly, textually, the power may not be qualified with any limitations, but implicitly, the power has limitations. That is a view, right? On the other hand, the analytical jurists, they argue that if the text is silent, then you can interpret the text in the you can interpret the text to progress. You can interpret the text to take forward the Constitution, but in the guise of interpretation, you cannot rewrite the Constitution. So that is another way of looking at the constituent power. In fact, Upendra Bakshi, when he wrote that very famous introduction to administrative law, IP Massey's administrative law, I think if I remember correctly, 2007 in edition, he wrote that very famous article, Nature of Constituent Power. And he clearly stated that he is not sure how to map the constituent of power, how to conceptualize constituent power. For example, if you read Justice Beg or Justice Matthew in Indira Nehru Gandhi case, now sometimes this power is characterized as a general legislative power. At others, this power is characterized as an amalgam of judicial, legislative, executive, and administrative power. Why amalgam? Because it is higher than all these powers. So exactly how to conceptualize the constituent power. Recently, I read a very interesting article wherein it is said that the theory of constituent power itself is problematic. Why? Because it is ambiguous, because whatever explanation it offers, there is a counter explanation to it. So basically, no version of constituent power can be accepted without controversy as such. Every version of constituent power has problems. Now, therefore, what is my position? What is my take on constituent power? I would argue that constituent Parliament of India has constituent power. And I would not like to indulge in a technical distinction between the constituted constituent power and original constituent power. I would argue that Parliament has a constituent power, and this constituent power of Parliament is above all other powers in the Constitution, right? And I would also take the position that this constituent power of Parliament also has a political dimension. It is not purely legal power. It is a blend. It is a complex blend of legal and political power. Now, friends, this is about conceptualization of constituent power, and it is as complex as it could get. Now, let me very briefly try and map the constituent, try and map the journey of the amending power in India through the lens of judicial review. How court has characterized the exercise of amending power. Now, friends, let me here say that right from the word go, Supreme Court started, or Supreme Court engaged in the creation of hierarchy. And how Supreme Court created hierarchy, I will explain. In Shankari Prasad case, which was the first case, what court did? Court invoked what can be characterized as a conventional hierarchy between constituent power and legislative power. So constituent power being, according to the court, higher power, it would be immune from the challenge of Article 30. So that was the argument in Shankari Prasad case. Now, in Sanjay Jain, there was a rift. This view, although continued in Sanjay Jain case, but two judges, and I adore both those judges, and particularly Justice Hidayatullah. Justice Hidayatullah and Bodholkar, they argued that can you continuously erode the fundamental rights? And to quote Justice Hidayatullah, whether the fundamental rights are playthings in the hands of majority, whether our constitution is majoritarian. And Bodholkar was wondering the pace with which we are eroding the institutions, the pace with which we are one after another trying to distort the fundamental rights. Would there be a day, would there be some day when court will have to examine whether enough is enough? So friends, clearly therefore, with very much, with lot of hesitation and with jaundiced eyes almost, these two judges said, yes, and the judgment was passed in Sanjay Jain. But the writing on the wall was evident. And then in this case also, the hierarchy continued, right? The conventional hierarchy continued. In the Golaknath case, famous Golaknath case, a different kind of hierarchy came into fore. And I would allude to this. How? Now, Supreme Court says in Golaknath through eloquent Justice Subbarao, whom I adore, again, a very creative judge. Subbarao says that how can you challenge the fundamentalness of fundamental rights? What authority? Where is the authority under the Constitution to the Parliament to erode fundamental rights? He asks. A very poignant question. From where you get the power to pass laws in violation of fundamental rights? Where is the constitutional authority? Where are the constitutional locations? Where exactly, in what provisions of the Constitution you would justify the power to erode the fundamental rights? And then he begins the journey. Okay, this provision, that provision. He finds no provision which allows Parliament the power to erode fundamental rights. On the contrary, he stumbles across a very important provision, Article 13. And he wonders whether Article 13, in its clearly injunctive tone, when it enjoins Parliament from passing laws in violation of fundamental rights, whether amendments by way of amendments to the Constitution in violation of fundamental rights would pass the muster of Article 13. And he does not agree with the earlier hierarchy created by the Supreme Court, the conventional hierarchy created by the Supreme Court, on the ground that jurisprudentially, in a written constitution, how can you have two different powers? How can you say that lawmaking power will be disciplined by fundamental rights, but another power whose location is unknown, according to Justice Subbarao, because it is not located by him in any provisions of the Constitution, barring the procedure to amend in Article 368, and merely by providing the procedure to amend, you don't also vest the power. That approach he takes. It may be a questionable approach, but his question that what is the qualitative difference between amending power and legislative power, so that only latter can be disciplined by fundamental rights? What is the qualitative difference, apart from the fact that the former is housed in a separate article? Merely housing a provision in a separate article, would it make it qualitatively different? So very ingeniously, he engages in what I call intra-constitutional hierarchy, right? So he elevates the status of fundamental rights by attaching a lot of importance to the words fundamental, and by disciplining the constituent power by situating it in residuary power, Article 248 of the Constitution. And then we all know the story, how Golaknath went without any luck. He went without any luck, because what Subbarao did very craftily, he applied the doctrine of retrospective overruling. So, although the first, 7th and the 17th Amendment were declared unconstitutional, the judgment was to be given effect retrospectively. So, in more than one ways, I think Golaknath was a titanic shift in the constitutional. It gave a titanic shift to the constitutional canvas in more than one ways. Then came Keswanand Bharti. And Keswanand Bharti came on the heels of some of the very interesting amendments which Parliament had made in responding, while responding to Golaknath, and particularly the 24th, 25th, and 26th and 29th amendments. out of which 24th, 25th, and 29th Amendment were dealt with by the Keswanand Bharati. Now, by 24th Amendment, the grudge of Subbarao was addressed, and Parliament said that okay, not only Article 368 House procedure, but it also houses the constituent power, right? But if you read the clause 1 after the amendment, okay, notwithstanding anything in this constitution, Parliament can amend the constitution by way of repeal, addition, or variation. So again, I'm reminded of a very crafty jurist, H.M. Sirvai. Notwithstanding anything in this constitution, that means something fishy. Was there anything in the constitution? So that you are trying to stop it by using non-obstante clause. And can you remove difficulties by merely writing something, by merely writing a rule by using non-obstante clause? So what Supreme Court said, and I think all 13 judges were in agreement so far as 24th Amendment was concerned. Those who were in favor of disciplining the amending power of the Parliament, they said that right from the word go, the amending power of the Parliament was not unlimited. But at the same time, they also stated that right from the word go, Constitution recognized the distinction between constituent and legislative power, right? So what they are trying to say, qualitative differences between the constituent and legislative powers must be recognized. And at the same time, they also said that it was not the case that constituent power was unlimited. But they also said in the same breath that there was not a single provision in the Constitution which was outside the reach of the amending power. So every provision of the Constitution was subject to the amending power. By saying this, they tried to push aside the Golaknath logic, because Golaknath had virtually created a kind of a hierarchy by making fundamental rights unamendable. Now, by way of judicial interpretation, if you make a particular chapter or particular part in the Constitution unamendable, I think it is a big ego clash between the two organs. So court very cleverly pushed aside Golaknath by saying that, okay, it is not correct to say that entire part 3 is unamendable. But then came a very surprising blow from the court with a sugar court. What court said? Fine, you enjoy your constituent power, because what you have done by 24th Amendment is merely making explicit what was already implicit. And therefore, you use your amending power subject to maintaining the identity of the Constitution. So, amending power can be used, but it cannot be used so as to destroy the identity of the Constitution, or to use the famous Supreme Court wording or phraseology, don't use constituent power so as to damage or destroy the basic structure of the Constitution, right? So the basic structure theory, which was inaugurated by the Supreme Court in Keswanand Bharati, very clearly stated that there are certain features of Indian Constitution which are inviolable, because those features constitute the pedestal on which the entire Constitution stands, and Constitution shall stand amended. You know, if you see the phraseology. So after amendment, if the Constitution falls, then you are indulging in suicidal pact. You are not amending the Constitution. So all kinds of metaphors were used, and somehow basic structure theory was created. Again, a new kind of hierarchy here was created by court, friends. Apart from supporting the conventional hierarchy between the constituent and legislative power, a new hierarchy, a hierarchy within the constitution, intra-constitutional hierarchy. Some provisions of the constitution being more important than the others. But, and it is a very big but, which are those provisions which are more important than others? Now, it is anybody's guess. Nobody can say with certainty that X, Y, or Z are the provisions which are more important than the others, because court said that we will decide case by case what really amounts to basic structure. And therefore, basic structure is a very interesting take, because since basic structure is not articulately defined, because it is only described, right? And the description of basic structure is relative to judges. And you know the famous dispute between Justice Matthew and Justice Chandrachud in Indira Nehru case, wherein Chandrachud was betting on equality and Matthew was betting on rule of law as one of the features of the basic structure of the Constitution. And Matthew was saying that equality is too nebulous to be a feature of basic structure, and Chandrachud was saying that rule of law is too nebulous to be the part of the basic structure. So friends, therefore case Swanand Bharti. Now comes the next case, Indira Nehru Gandhi. In Indira Nehru Gandhi, Sirvai says basic structure was strengthened. Sirvai says basic structure was identified, concretized. Now, in my opinion, and I borrow here the ideas of my guru, Dr. Deshpande. In fact, I want to make this point very clearly. I say that Indira Nehru Gandhi, in fact, overruled Keswanand Bharti. And Indira Nehru Gandhi considerably watered down the notion of basic structure. You will say, what are you talking? Are you joking? Are you trying to say that what Supreme Court says, what Sirvai says is wrong? With great respect, I would say that it is my view. It is the view of both of us. We recently propounded this view while reading a paper in Zindan. Right? Now, let me explain and articulate this view, because this is a very serious point which I'm trying to make. Now, what happened in Indira Nehru Gandhi? I think court was not bothered about basic structure in Indira Nehru Gandhi. Court was only bothered about the exercise of judicial power by the parliament. And very clearly, the crux of the judgment in Indira Nehru Gandhi was because the parliament arrogated to itself judicial power without first arming itself with the judicial power. Had there been first an amendment to the constitution and had parliament been empowered, had parliament empowered itself with judicial power, and then had parliament exercised such a power to take off the case from Allahabad High Court and then pronounce Mrs. Gandhi to be innocent, it would have been a different story. So all judges were concerned, how dare you to exercise judicial power directly? In other words, all the judges were saying, how dare you to present judicial power as a constituent power? So the anger of the court was much. Court was angry much more because its power was being arrogated by the parliament. But in all other respects, whether court had any difficulties, with the creation of separate institution to deal with elections of prime minister and president, no. Court said all right. Whether court had any difficulty in accepting retrospective incorporation of election law in 9th schedule by way of amendment, court said no problem. Even the court disputed, the judges disputed, they wrote, all the 5 judges wrote 5 different opinions. And the opinion of Justice Beg, it's anybody's guess what he exactly wrote in that opinion, right? So, if at all Indira Gandhi Nehru was a case concretizing the basic structure, then there could not have been 5 judgments. There could not have been a big dispute between Matthew and Chandrachud. And therefore, in my opinion, which is of course strengthened by Dr. Deshpande's counsel, I argue that Indira Nehru Gandhi merely complained about misuse of judicial power. It complained about misrepresenting judicial power as constituent power. And therefore, it is not at all a case on basic structure. Right? And therefore, I want to argue, while concluding the first part, look at the shift, paradigmatic shift in the approach of the court as we went on traveling. It went on to give judgments after judgment. It realized that in Indira Nehru Gandhi, it had already damaged the reputation of the doctrine of basic structure. So it wanted to give it a flavor. In Nagaraj, therefore, it went rock, stock, and barrel. It said that basic structure is a constellation of constitutional axioms. It is a conglomeration. It is a cluster of principles which are beyond the provisions of the Constitution. So the shift is from provisions to principles, right? And of course, court is also talking about founding values. So now court is saying, after Nagaraj, basic structure commits itself to values and principles underlying the Constitution, or values and principles constituting the bedrock of Indian Constitution. Now, friends, there are some very technical arguments about amending power. For example, if you look at Keswanand Bharti case, now Sharath is probably listening to the lecture. I happened to write with him in my book, which I co-edited with Ms. Satyanarayan, our senior colleague in Law College. I have said there that we have different versions of basic structure. If you look at Justice Khanna's basic structure model, for example, it is both mono-provisional as well as multi-provisional. Why mono-provisional? Because in the first half of his judgment, he says that amending power is subject to limitations because of Article 368 itself. 368 itself inheres. It is inherent. The amending power comes with inherent limitation. So mono-provisional. But in the later part of his judgment, he also says that basic structure is subject. The amending power is subject to implied limitations. So very difficult to really club together his two views. Then Justice Sikri, he uses multi-provisional model, structural interpretation of the Constitution. Then other judges, if I remember, I think 2 judges, they equate basic structure with essential religious practices. So just as we try to confine the freedom of religion to essential religious practices, so essential features of the Constitution.
Sorry to
so you have
interrupt,
different pairs.
Sorry to interrupt, sir. Deshpande sir just joined our meeting.
Oh, great. Wonderful. So, this is another interesting version of the basic structure. They're equating essential religious practices with basic structure, right? Just a minute. Now, in some later judgments, particularly the judgment of Chandrachud in Minerva Mills case, he's trying to identify basic structure in the concrete provisions of the Constitution. And then come the Nagaraj discourse, wherein now the court is saying that the basic structure has to be aligned to the constitutional axioms or constitutional principles. So, I mean, it's a very nuanced and a very very complex interpretation of the court so far as basic structure of the Constitution is concerned. Now, how court decides whether a particular amendment is violative of basic structure of the Constitution. Now, the analysis is never an analysis based on the assumption that there is something like basic structure. Analysis is not like that. So, court first examines the impact of the amendment. The court first examines the impact of the amendment on the Constitution and then investigates whether the impact is adverse or it is positive. If it is adverse, then court tries to find out whether the adversity of the impact is so severe that it would damage the identity of the Constitution or basic structure of the Constitution. So the inquiry is post hoc. Inquiry is not ex ante. It is post hoc. So therefore, basic structure is a conclusionary premise, right? Basic structure is a conclusion. It is never a minor or major premise. So major and minor premises are the amendments, and then court will reach the conclusion, testing the validity of the amendments, whether they are in violation of basic structure, right? So, for example, therefore, suppose an amendment is made to the Constitution, Article 16(4)(a), providing reservations in promotion or providing creating exception for carry forward of vacancies, 16(4)(b). Now, when such amendments are challenged, what court did? Court tried to find out whether these amendments, whether they impact the entire Constitution or whether they impact a particular portion of the Constitution. They realized that these amendments only impact Article 16(4). Whether Article 16(4) constitutes the identity of the Constitution, or whether it or whether the amendments to Article 16(4) would promote egalitarian equality, would strengthen the affirmative action. Court came to the conclusion that yes, it does strengthen the equality, and accordingly the amendments were held constitutional, right? So what I'm trying to say is that the logic of the court in deciding the basic structure cases is not uniform. It is not consistent, right? You have variety, right? If you read R.C. Paudel, you get something else. If you read, I have already shown how in Indira Nehru Gandhi, court was completely away from basic structure. In fact, court was concerned only about judicial power. Friends, having concluded my first part, because time is running, now let me go back to my second part. And I want to take up for consideration the First Amendment. And here, I really, me and Dr. Deshpande, we had disagreement, mainly because Sir was insisting that you should argue, or we should argue legally, and I was insisting that if law is I don't want to argue by using a colonized law, right? I want to decolonize law, right? And I think this discussion is unending. But I agree that if you want to argue on the plank of pure law, then of course whatever I am going to say may be not very convincing. But for me, colonized law is not at all a satisfactory model of law, right? We did not struggle for independence to perpetuate the colonial law. We wanted an emancipatory law. So whether we have really perpetuated the emancipatory law, that's what I want to examine. Although this question is a very, very broad question, and it would be unfair to answer this question in the light of only one amendment. But let me do the venture. So what was done when First Amendment was enacted, when the Constitution was amended in 1950? Three major blows were given to the Constitution. So let me first briefly explain those major blows. Firstly, Article 19 was very, very thoroughly amended, squarely amended. And what was different prior to what was originally Article 19? What is Article 19 after the First Amendment? Prior to First Amendment, there was nothing like reasonable restrictions. Parliament, of course, and the states were, of course, empowered to either use existing laws or use their legislative power to deal with security of state, defamation, slander, contempt of court, etc. So those powers were there, which should be there with every civilized state. But Nehru was not happy with these powers. And what made Nehru unhappy is very interesting. Some High Court judgment. I think Jawaharlal Nehru was a barrister, if I'm right. And I think he should have waited for the final judgment by the Supreme Court. But based on the High Court's judgment, Nehru was in panic. So one of the judgments, of course, was Ramesh Thapar's judgment, right? Because Nehru really was against dissent, basically. No dissent, right? If you praise him, he will be happy. If you write anything against him, he will be unhappy. And that's what is very clearly demonstrated by the Tripur Daman Singh's book, where page by page he has shown how Nehru used to get angry with press. Nehru used to get angry with his opponents. Anyway, now the second blow, and it was a very interesting blow. Article 15(4) was added to the Constitution in response to Champakam Durai Rajam case of the Chennai High Court, because the judgment of the Supreme Court was yet to come in that case too. And court said, the Parliament said, the Nehru said, his view was that we should have affirmative action in favor of the backward classes. But again, the insistence was that backward classes means only socially and educationally backward classes, and SCs and STs. Now, there were other voices in the Parliament who said, okay, fine, if you want to add this new provision, why don't you also take into account economic backwardness? But no, Nehru would not listen. Only socially and educationally backward classes. And it took 66 years, or even more than 66 years, I think 70 years, to reach the economic backward class had to wait for 70 long years for the reservations to come. But I think the third blow was the real surprise, because apart from seriously watering down the right to property by completely revamping Article 31, what Nehru did was something very interesting and unheard of. He said, let's have a mechanism in the Constitution to provide refuge to constitutional law violating laws. Okay, so I want to violate the fundamental law to which I am by which I am bound. In fact, I am the creation of fundamental law, but I don't want to abide by this fundamental law. I want to enact laws in violation of this fundamental law, and I want both this fundamental law and constitutional law, constitution violating laws to go hand in hand. So he was trying to blow hot and cold. Have a cake and eat it, right? A classic example, right? What one of the professors from London School of Economics called the typical colonial law, when law provides for its own violation. Right? Now, these amendments were made by Nehru under tremendous pressure. He put the entire cabinet on fire. He put a lot of pressure on President of India, and he put a lot of pressure on intelligentsia. Only one answer Nehru would give whenever the amendments would be questioned: I will resign. And the tropes on which he would defend these amendments are very interesting. I'm not making these amendments for me. I want to protect the future generations. And therefore, I'm making these amendments. Now, what future you would protect by enacting 9th schedule in the Constitution? What future you would protect by introducing vague ground like public order in Article 19(2)? What future you would protect by allowing the revival of infamous sections like 124A and 153A, sedition and religious animosity prevention laws, right? Now, the Congress brigade argues that Modi government is misusing these sections. But who invented these sections? Who revived these sections? You have to ask. Now, let me puncture the legal architecture of the First Amendment, because it is extremely necessary to go into the legal architecture of the First Amendment, which is, I think, not examined by anybody very seriously. Now, how First Amendment was made? In order to amend the Constitution, there were a lot of difficulties. So a very famous instrument was evolved by Parliament. It is known as the Second Removal of Difficulty Order. Removal of Constitutional Removal of Difficulty Order number 2, right? Now, generally, those who study administrative law, they know that removal of difficulty clause is there in statutes. So the first question which can be asked is, should such a clause be there in the Constitution? Are you trying to equate Constitution with statute? But assuming for the sake of argument that to some extent Indian Constitution was a statute because it was in continuum from Government of India Act 1935. Okay, agreeing for the sake of argument. In the guise of removal of difficulties, can you make, unmake, and repeal dozens of articles in the Constitution? So if you see the slide, you will be amused. Bewildering number of articles are altered, a number of articles are omitted, and new articles are enacted. Can you amend the Constitution while removing the difficulty? And when you see the scale of the alterations through this order, ideologically, I have to ask myself whether Constitution was such a difficulty, whether Constitution of India was such a gigantic difficulty that Nehru had to resort to illegitimized presidential power to pass an order. Of course, critics may argue, what are you talking? Under Article 392, Clause 2, the order had to be laid before the Parliament. But we all know how Parliament scrutinizes the administrative rules. What is the fate of delegated legislation in India? What is the level of scrutiny of delegated legislation? But anyway, this order adapted Article 368, which is most interesting. Along with other articles, the removal of difficulty order also altered Article 368. In other words, you are trying to amend the amending power provision itself. And it replaced two houses, wherever the terminology two houses was there in Article 368, it replaced it with the word Parliament. So that a provisional Parliament with a limited franchise, without any popular legitimacy, a limited Parliament, a transitional Parliament, a provisional Parliament with limited franchise, which was supposed to be an ad hoc body till the elections. It was a body entrusted to continue the execution of the Constitution till a Parliament is constituted. A bicameral Constitution is bicameral Parliament is constituted. This body, this unicameral body, assumed to itself, arrogated to itself, in my opinion, the amending power and gave these three considerably heavy blows to the Constitution. In fact, in my opinion, 9th schedule is the villain of the piece. Because what was the urgency for Nehru to have gone for 9th schedule at least? Why he did not wait for the elected Parliament? Now, there are a lot of questions. When you look at these amendments, there are a lot of questions. My first and in Shankari Prasad case, when these matters were argued, although Article 19 amendments to Article 19 were not questioned in Shankari Prasad, but Article 31 amendment to Article 31 and 9 schedule was questioned. But what court said? You don't question these amendments on the ground of violation of fundamental rights, because amending power is immune from Article 13, and matter ended there. Basically, the court did not take very seriously the argument based on legitimacy. For example, the argument whether provisional parliament was having legitimacy to make such the kind of amendment it did. But one very technical and very interesting argument which was made in Shankari Prasad. The argument was, okay, Article 368 is a complete code. And therefore, once you introduce an amendment in the parliament as a bill through the door of Article 368, then the subsequent amendments during the discussion, as you can do to legislations under Article 107 or under Article 107 onwards, those things you cannot do with amendment. That was the argument. In other words, the bill which is introduced in the parliament by the government, either through Lok Sabha or Rajya Sabha, in the same form, such bill has to be passed by the parliament as an amending body. You cannot allow amendments, or you cannot promise amendments. You cannot allow opposition amendments, or government, for example, is not allowed to make amendments. That was the argument which was being made. And I think it was a formidable argument. After all, you yourself say that there is a qualitative distinction between legislative power and amending power. So if a amending bill is introduced by the government in the parliament to the amending body, and mind you, when constitution is amended, it is not parliament, it is amending body. Now, constitutional amendment is different from legislation. So after a great deal of consideration, you would introduce such a bill to the amending body. So why then the bill should be further amended during the deliberation? If at all the amending body has any problem, the bill must go back to the government, and government must repair the bill and again introduce it. But court said nothing doing. Just like any other legislation, even the amending bill is also subject to discussion, and subject to discussion means subject to amendments. Court said that because of Article 392, because Article 392 gave President the power to remove difficulty, President could remove every difficulty, including, interestingly, the difficulty of Article 368. Now, mind you, it is unheard of that removal of difficulty clauses will be invoked to make substantive changes. I agree that procedural matters can be dealt with. And now let me go to the Constituent Assembly on this matter. This matter was also before the Constituent Assembly. In fact, if you read the Constituent Assembly debates on Article 368, which was draft Article 304 in the second draft, and Article 232 in the first draft. If you read Sivrao, around 9 pages, and if you read CAD, around 39 pages. I read both. Now, there was a proposal floated by B.N. Rao to the effect that for 5 years, Parliament must be given the authority to amend the Constitution with simple majority. Right? Without any hurdles, because everybody was suspect about the workability of the Constitution. But that power was denied to Parliament when Article 368 came, when Article 304 actually became Article 368. No such power was given to the Parliament. In other words, if framers of the Constitution, if they wanted to give extraordinary power to the Parliament, they would have given. Merely they gave the removal of difficulty power to the President. Going by the Kelsonian logic, can an inferior norm adversely affect the grand norm? Now here you are writing a death wish of grand norm by inserting 9 schedule. So where is the logic? I mean, you are using simply administrative power. You are using executive power. In fact, government by executive fiat is an anathema to rule of law, right? And we were just in the initial phase. We were in the honeymoon of our constitutional working, and you are writing a death wish of constitution by enacting 9 schedules. Now, friends, therefore, I personally feel that Nehru prepared the groundwork for kind of personality-oriented politics. It was a personality cult which was perpetuated by Nehru, and his daughter completed the work, by enacting the 42nd Amendment. I will fail in my duty if I don't mention the protest of Rajendra Prasad. Rajendra Prasad asked Nehru, "How dare you to amend this constitution? Amend the constitution like this? How dare you, as a ad hoc unicameral body with limited franchise, to give such big jerks to the constitution?" But Nehru said, "I will resign, or this amendment will happen." So it was a fait accompli. Even Nehru warned Rajendra Prasad not to make his counsel public, and therefore only now, when scholars are going into archives, we are finding out the truths. We are finding out the real picture. What was people? Everybody, the press was asking, what about the cherished goals? What about the mission for which Nehru was ready to give everything? What went to that? What happened to the idea that power corrupts and absolute power corrupts absolutely? I think, while concluding, I would argue that Nehru inaugurated the era of empowering the state at the expense of citizens. Right? His formula was probably this: that by empowering the state, you empower the people. But are you really doing that? By what happened to 9 schedule? One after another, you have dozens and dozens of laws going into 9 schedule. Ultimately, court was required to interfere in Kohinoor's case. Court was required to say to Parliament, wait a minute, what about basic structure? So therefore, friends, in my opinion, the First Amendment itself was a very big blow to the original constitutionalism of India. Therefore, no wonder if Supendra Bakshi calls it the first constitution. Some people may say that Nehru inaugurated socialism. I would argue that socialism should have been inaugurated, even if it is argued, even if it is assumed that he inaugurated socialism. He also at the same time suppressed the rights of the citizens, cherished rights of the citizens. And particularly, I think history should never forgive him for writing the death wish of the constitution, the 9th schedule. Right? At least the subsequent parliaments should have learned the lessons and should have undo the damage of 9th schedule. But what happens when you test the blood? And Nehru gave the test of the blood to the politicians, and politicians love nothing more than power. Therefore, as they say, power corrupts and absolute power corrupts absolutely. I think 9th schedule created kind of a, the people simply started riding on 9th schedule. And the best example is Mrs. Gandhi's election law amendment, right? In order to invalidate a judgment of Allahabad High Court, she amended the constitution and used 9th schedule to assert immunity. So friends, I think one area I could not cover, types of amendments, because of paucity of time, although you must have seen the slide. But I think otherwise I have tried to cover everything. Now my problem is, generally I use braille notes whenever I speak on serious topics like basic structure. But due to lockdown, my printer is in lock in the college, and I think I should give a lot of credit to my wife for helping me with this PowerPoint. And I've tried to accommodate, I think, all of you by using PowerPoint and by explaining the slides. And I would be very happy to take questions, if any.
Yes, sir. I'm Advocate Honey, please questions.
Yes, sir.
Yeah.
So I can see the one question over here.
Yeah.
Recently, Justice D.Y. Chandrachud has set aside the judgment of late Justice A.Y. Chandrachud. What is your opinion about this?
I could not hear you properly. Yeah, your voice was.
Yes.
So recently, Justice D.Y. Chandrachud had set aside the judgment of late Justice A.Y. Chandrachud. What is your opinion about that one?
Yeah, he overruled the Shukant Shukla judgment in Pattaswamy case. I think it was more a symbolic gesture than any other thing, because with the 44th Amendment, the judgment of the Supreme Court in Shukant Shukla had already been considerably nullified by Parliament, because now under Article 359, the position is very clear that even during emergency, Articles 20 and 21 cannot be suspended, right? But I think still, even symbolically, overruling a monumental judgment like Shukant Shukla, right? A monumental because of its infamousness, because during those days in 1975 to 1977, because of that judgment, many people had to stay in jails, right? I think we should admire Justice Chandrachud for showing magnanimity. Right?
So the next question is from Manoj Agarwal. From which part of the Constitution Supreme Court derives power to select cases for admitting matters hearing under Article 32?
Can you repeat your question? Your voice is cracking.
Honey, your voice is cracking. Let me take the question.
Okay.
Sir, this question is from Manoj Agarwal.
Okay.
From which part of Constitution Supreme Court derives power to select cases, decide cases, whether to admit matter for hearing under Article 32?
Which power? Okay. Article 32 itself gives power to the court, right? Because although right to approach Supreme Court is a fundamental right to remedy the right to seek remedy for the violation of fundamental rights is a fundamental right, but we have to follow certain procedures. We have to follow certain modalities, and to that extent, Article 32 itself gives power to the court.
Sir, second part of sir's question is whether Supreme Court, which acts as guardian of Constitution of India, take out directly, indirectly, right to be heard under Article 32 from few many citizens.
I don't know. I mean, but if you look at the record of the Supreme Court, barring some exceptions, as a guardian of the rights of the citizen, I think court has by and large heard the cases under 32, and when court found it difficult, court has advised the citizens to approach high courts. So I don't think it would be fair to say that court has suspended right of hearing while admitting cases. Sometimes the cases may be frivolous. Sometimes the cases the petitions may be incomplete. Petitions may be problematic. But generally, because we have this very important aspect, we have expanded the locus standi. We have epistolary jurisdiction. Even by writing a letter, you can move the Supreme Court, right? So therefore, I don't think it is a very fair comment to say that court is denying or suspending the right to hearing.
Okay, so there were 3 questions from Manoj Agarwal. Last part of his question is whether
Yeah.
this is not violation of Article 32, read with Article 13.
Read with Article
13, 1-3.
Okay. Now, first of all, Article 13 is not applicable to judiciary, right? Because Naresh Biraskar's judgment is there. Although Justice Hidayatullah in his dissenting opinion had argued that judiciary should be perceived as a state. And I also believe that when court performs its judicial function, how can you challenge the judgment of the court under Article 13(2)? The option is either review, curative petition, or if the judgment is given by High Court, then appeal, right? Article 13 basically is directed at executive and legislature. It is not directed at judiciary. Of course, when judiciary becomes executive or legislature, for example, when judiciary enacts, pronounces judgments and virtually enacts courts like Visakha, then of course there is a scope for using 13 like inquiry. Still, I would say that it is not the case of invocation of Article 13. And I think in Antulet's case, court admitted that it would correct its mistake. But court accepting its mistake and correcting it is one thing, and disciplining the judgment of the courts with Article 13 is quite another. And I don't think you can discipline the judgments of the courts with fundamental rights. Of course, you can discipline the court's judgments which sound like legislation by using curative jurisdiction or review jurisdiction.
Okay, sir. Next question is from Sharat Chandran, who is joined from Chennai.
Yeah.
Does the amendment to Article 368(1), describing it as the power and procedure to amend the Constitution, confer any power, or is the 24th Amendment merely declaratory in nature?
Well, we have discussed this point so many times, right, in the college. In my opinion, court had already made up its mind, and because court wanted to keep its image intact, and at the same time wanted to restore the parliamentary supremacy, therefore court merely characterized 24th Amendment as declarative, right? Because court very clearly stated that the power to amend was already there. I mean, how can you? The argument is very interesting. How can you have a procedure without power, right? And particularly if you agree that there is a qualitative distinction between amending power and legislative power, then it goes without saying that procedure would also embrace powers, right? Therefore, the powers were already there, and 24th Amendment was merely declarative. Yeah.
Okay, sir. Thank you, sir. There is no question, no more questions. Just I want to convey a message from Bharti Dubey, madam.
Yeah.
Salute to you, sir. You are such an inspiring personality. Nothing can stop a person from achieving anything if you have the dedication. You are a personification of it. Always wearing $1 million smile. Dandvat pranam, sir. And,
Yeah.
Yes.
I would like to thank the organizers, particularly Sandeep ji, to you, and my colleague Praful for giving such a very good introduction, and particularly thanks to those who asked questions. I believe that, as a teacher of constitutional law, constitutional law is that canvas which keeps you going, right? Whenever you read it, you find something new, right? So, for example, this idea of hierarchy, right? When I was discussing the lecture with Dr. Deshpande, this idea of hierarchy came to our mind. So, my advice to all the youngsters is take Constitution seriously, read it, and think it, right? I would also take this opportunity to inform all of you who are listening to me that there are many interesting courses happening on web. For example, I am myself registered for as many as 6 different courses. To name a few: liberal constitutionalism, constitutional change, Constitution of Canada, Constitution of USA, etc., etc. So all these courses are there. They are on a very small price, $10, $15. So during this lockdown period, let us unlock our mind, right? by taking full advantage of these courses, because it is a lifetime opportunity to have one-to-one with professors like Nicky Jackson, Bruce Ackerman, Mark Graber, Tom Ginsberg, etc., etc. Again, I would like to thank my audience and Sandeep.
Sir,
Yes, sir. Sir, if you permit, Manoj Agrawal wants to say something.
so thank you for your clarifications. Maybe my question was not it. I was not actually trying to question, but these questions was striking to my mind, because when I see some of the, I would not say it will happen every time, but when we read the news and there are scenes like some cases which are important and lying, that they are not even being listed or not heard, that's where these questions come to my mind, whether the court has such power to decide itself that whether.
I follow you, and I also follow the hint, the Aruna Goswami's case, how it came out of turn, right? I follow. These things happens. Indeed, there are few mysteries, and let mysteries remain mysteries, right? I mean, what can you say? Supreme Court is supreme. I mean, this is the last argument, and I follow your anxiety. I follow your anxiety. Even Justice Chandrachud the other day, while giving seminar, he also said the same thing, but he only said that don't overgeneralize it, right?
Not my point was not to overgeneralize.
No, I'm just trying to rehearse what Justice Chandrachud said, because the same point was also came to him. What about prioritizing some undeserving cases over a lot of deserving cases, right? So I follow you, and I fully sympathize with your position. In fact, I know who know better than me, as a representative of a marginalized section of society, what is the plight of the people with disabilities when they go to the court. So I agree, that point is there, but you have to also take into account the arrears. You have to also take into account the humanly impossible tasks which the judges are required to perform. I mean, can you imagine the number of cases our judges handle compared with the other jurisdictions? I mean, look at the position of the Supreme Court judge of US vis-a-vis the Supreme Court judge of India. So I think there is a lot of scope for improvement. Hopefully things will improve. We have to be optimistic.
Thank you very much, sir, for your insights on this rare topic. I would like to request Advocate Nishan Bardia to propose vote of thanks.
Am I audible, sir?
Yes.
Very fruitful session it was, sir. Actually, it was full of new ideas. Sir gave us very eminent lecture, and as well as new ideas. I would like to sincerely thanks Mr. Sandeep Sadbhai, sir, for giving me this opportunity to propose vote of thanks. Respected Professor Dr. Sanjay Jain, sir, and our most valued invited guest, all our participants who have joined from Chennai, Baroda, and all across Maharashtra. It's my privilege to have been asked to propose a vote of thanks on this occasion. On behalf of New Law Guruji web lecture series, I must mention our deep sense of appreciation for Sir Dr. M.S. Gosavi, sir, Secretary of Gokhale Education Society, as well as NBT Law College, Nasik, and Principal Asmita Vaidya, madam, for their guidance and encouragement to run activities like lecture series. Definitely, this moment will reach to national level so that everyone will get benefited by lecture of stalwarts all across India. And on behalf of all, I attend a very hearty vote of thanks to respected speaker as well as all participants. As well as I would like to thank some special guests who were attended the lecture. Advocate Seema Sarnaik ma'am from Bombay High Court, Mumbai, as well as Dr. Archana Gadekar ma'am, Dr. Shirish Deshpande sir, Dr. Advocate Sharat Chandran sir from Chennai. All of these eminent personalities have attended the lecture. I would like to specially thanks to all those persons, as well as a big thank you to respected Professor Dr. Sanjay Jain sir, respected Professor Dr. Shirish Deshpande for their efforts towards today's critical topic. And I would like to propose a vote of thanks to every person who have participated and taken efforts to fulfill these and complete the web lecture series. Thank you.
Thank you very much.
Thank you, all participants. Thank you once again, Sanjay.
Thanks.